The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
And you're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. Attorneys Will Morris, Shea DuPont, and our toll-free line, 866-610-NEWS, 866-610-6397. If you're in the car, if you're shopping, and you're listening to us on the iHeartRadio app, you can still call the show with your questions, concerns, doubts, stories, 866-610-NEWS, 866-610-6397, AT&T Wireless customer star 610. And on the phone, we have John.
We do have John. We were talking about a homeowners association and getting the lien, or I should say,
they're foreclosing against the property,
buying the home.
Third party purchasing the home.
Oh, thank you.
And whether or not they can then sue the homeowners association based on the fact that the bank is now foreclosed against the property.
Did we answer your question for you, John?
One more question.
Go ahead.
The final question is, when the foreclosure takes place, does the bank settle with like the city of Sunrise for the water, or if there's a balance from the HOA, does the bank settle with these institutions?
Oh, that's a good question. Now, normally what happens when the bank forecloses, again, it forecloses against all secondary liens, all junior liens. And to the extent, most of the times these cities and municipalities, they don't appear in a foreclosure lawsuit. They don't even file an answer. They don't present their position. And what happens in the final judgment is that their interest, their lien gets wiped out. Now, when it comes to HOAs, there's a whole different story going on there. Now, when the bank, let's assume the bank or even a third party acquires title to the property following a foreclosure sale, then that bank or third party can then become responsible to the homeowners association for the portion of the past due amount. Now, there's a cap on the amount the bank or the homeowners or the third party purchaser is responsible to the homeowners association. I think it's 12 months worth of past HOA fees,
right,
or 3% of the 1% of the purchase price, something along those lines.
Okay.
All right. Well, thanks for listening to the Home Mortgage Law Show, John. We appreciate you tuning in. I want to talk about the locations where you can meet with us and have your free consultation with the law firm of Morris DuPont. Remember, we have offices available in St. Petersburg, Tampa, Dadeland, Doral, Aventura, Fort Lauderdale, Plantation, Boca Raton, and West Palm Beach. Basically, if you can hear our voice, there should be an office nearby where you can schedule your free consultation. You can call the law firm of Morris DuPont. The telephone number is 800-974-2712. That's 800-974-2712. You can schedule your free consultation. You might be meeting with me, Shea DuPont, my partner, Will Morris, J.C. Castro. We're all available to meet with you for these free consultations. What we do is we sit down with you. We look at a mortgage statement. We look at the value of the property. We crunch some numbers. We look at your income, and we tell you what programs you might qualify for or what you might not qualify for, and tell you what your different options are. Of course, it's up to you to decide which one of those options you may or may not take, but we're there to inform you, educate you, let you understand exactly what your options are. We want everyone to make educated decisions about this very important issue, which is, what should I be doing with this property that I own? Does it make sense to keep it? Does it make sense to modify, short sale? Possibly, can I get a second loan wiped out? Lots of different options.
We have a caller, Isnard.
Hi, Isnard.
Hi. My situation is not that I'm underwater.
Okay.
Obviously, and the home was under IndyMac. It was purchased out by Aquin. It's an adjustable rate mortgage.
Ooh, like it already.
And, yeah. All I really want to do, and all I've ever tried to do, is I've kept current. I have no late payments. All I've ever wanted to do is have them converted to a fixed. I'm not even looking for a principal reduction. I've always paid on time. I'm a good payer. I'm not in a financial situation, but I don't qualify for anything according to them because I used to be either Freddie or Fannie when it originated with IndyMac, and then somewhere down the line they purged me.
Somewhere down the line they what?
Well, somewhere down the line, either Freddie or Fannie, wherever we were under, it originated under Freddie or Fannie, they It's no longer under Freddie or Fannie, as I understand it.
Really? So I would want you to check that. So first I want you to double check under knowyouroptions.com or knowyouroptions.something, or look up use these keywords: Fannie Mae loan lookup, Freddie Mac loan lookup. Use those search words, keywords to do an internet search and go plug your information, your name, your address, and the last 4 digits of your social in where they ask, and make sure and see if it's a Fannie or Freddie, because you can't get a principal reduction on it if it's a Fannie or Freddie. Otherwise, because it's Ocwen and you have negative equity, and because, as I've been discussing, Ocwen just entered into this $2 billion settlement, they're going to be handing out principal reductions like candy. So I'd love for you to qualify for that. So that's the first thing. So let's see whether or not it's a Fannie Freddie, and then see whether or not you can qualify. This is the formula you want to keep in mind. Are you today paying more or less than 31% of your gross monthly income towards your housing expense? Housing expense.
I don't believe so, no.
Housing expense is defined as PITIH: principal, interest, taxes, insurance, and homeowners association fee. If those 5 factors together are showing up as more than 31% of your gross monthly income, Ocwen is required to modify you.
Okay.
Even if it's a Fannie Freddie, they have to modify you. If you're currently paying less than 31% of your gross monthly income towards your housing expense, they don't have to do anything. You're already at or below the national average.
Right. And now, the other thing is, if I don't qualify for principal reduction, all I really want to do is make it a fixed rate rather than an adjustable rate.
You don't negotiate whether or not you are going to get a principal reduction. It will have to, if you qualify for a loan modification, you're going to have the loan converted from an adjustable rate mortgage or interest only or pick a pay, whatever it is. It's always in a loan modification. It always goes to a fixed rate mortgage. And it always includes the escrowing of taxes and insurance. So you don't have a choice. You're going to be in a fixed rate. It's either going to be 2% under HAMP or an in-house, or if it's a Fannie Freddie, it'll be somewhere hovering around 4%. And it'll be fixed, and it'll include the escrowing of taxes and insurance. That's not an option. Whether or not they're going to give you a principal reduction, you can't choose. They figure out whether or not that's what the investor that owns the note wants to do. Because remember, Ocwen is a mortgage servicing company that services loans on behalf of the investor that owns them.
Well, Shay, what about the fact that he's still current on his mortgage?
Yeah, that's an issue. That's the real reason why you've never qualified for a loan modification, Isnard, is this. The real reason that you never qualified is because you're current. You're going to have to go a rolling 30 to 60 days past due. We show you how to do it. Very minimal damage to your credit, but that's what you're going to have to do. This is part of what happened with Ocwen. This is what Ocwen was accused of by the Consumer Financial Protection Bureau and 49 attorney generals around the United States. And this is what the complaint says that Ocwen did. It deceived consumers about foreclosure alternatives and improperly denied loan modifications. Quote, it failed to provide accurate information about loan modifications and other loss mitigation services. Quote, it failed to properly process borrowers' applications and calculate their eligibility for loan modifications. Quote, it provided false or misleading reasons for denying loan modifications. Quote, it failed to honor previously agreed upon trial modifications with prior servicers. Ocwen is just like these other servicers. It was doing all of these horrible things. You might qualify, but you need to come see us, and I'll, for free, let you know what I think.
And that number to book your free consultation, thanks so much for your call, Isnard, is 1-800-974-2712. 1-800-974-2712. Toll-free number, free consultation. Can't get better than that. 800-974-2712. The law firm of Morris DuPont. More of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by Morris DuPont PA Regal Tax Advisory Group. Attorneys Will Morris and Shay DuPont here for you. Our toll-free line here on the show is 866-610-NEWS. 610-6397. AT&T Wireless customers star 610.
I really am excited about this Ocwen settlement. Isnard called and, because his loan was with Ocwen, it made us start to talk about it. But let's get into some of the details of it, because Ocwen just settled with the Consumer Financial Protection Bureau and with the attorney generals around the United States and the District of Columbia, and it settled a complaint by the Consumer Financial Protection Bureau and the attorney generals. And you just can't believe, well, I can, but it's still shocking to me. I'm naive. I think everybody is good. And, it wasn't until I started practicing in this area of law that I realized how many of these corporations just do everything that they possibly can for the bottom line. They don't care about you one single bit.
Not at all. They stymie every effort people try to make to try to save their houses.
Right. And you think it's so short-sighted, because they'd be better off if they just help people. One of the things that always has bothered me, and it will bother me till the end of time, is when these lenders will not accept payments any longer. So let's say you've missed 2 months of payments. All right. Something happened. You had a medical issue. You had to pay medical bills and you couldn't make your mortgage payment. And then you want to start making your mortgage payment again, and you call your lender and you're now 80 days past due. And you say, okay, I know I've missed 2 payments. What I'd like to do is I'd like to start paying on time, and I'd like to maybe pay another $75 a month
to catch up.
And I can do that for the next 3 years.
Ordinary business makes sense.
It would, wouldn't it?
Yeah.
I mean, the person's trying to get back in good stead. I'm sorry they missed 2 months, but it's a 25 years left on a loan. So what's the big deal about letting them, add a little bit more onto their payments? They're going to pay interest on it anyway.
Right.
So you're going to make money on top of money. Why won't you let them do that? But no, I've never heard of a lender accepting that offer from a borrower ever. What do they always say?
Call our attorneys.
And either make all the past due payments, or we will return checks that are less than the full amount.
Right. Or worse than that, we consider you in default and we refer the file to our attorneys.
Yeah.
Which usually means more fees.
More fees on top of more fees. And it's not like you're going to collect that money from most people. They don't have it. So the property's going to go in foreclosure. The lender's going to have foreclosure fees on top of, foreclosure fees that they have to pay their attorney. The property's going to sell for less. I mean, it doesn't make sense to me. Why don't you let the borrower get into a payment plan where they pay a little bit more every month for a couple of years and make up the 2 months of missed payments? But no, they won't do that. They're like, no, you either pay the entire past due amount plus the late fees, or we're not going to accept any partial payments.
I've heard a pro se litigant make that very same argument before a judge, and the judge said, "Well, everybody has a right to make a stupid decision."
But why can't the Consumer Financial Protection Bureau try and help with something like that? I mean, so that drives me absolutely insane. So let's get back to Ocwen. So Ocwen enters into this consent judgment where they're consenting to a judgment, and they are going to have to pay homeowners principal reduction relief of up to $2 billion. But listen to what Ocwen consented to. That they took advantage of homeowners with servicing shortcuts and unauthorized fees. They failed to timely and accurately apply payments made by borrowers and failed to maintain accurate account statements. So if you've got you're getting a monthly mortgage statement from Ocwen, don't believe that it's accurate, because Ocwen was very often wrong and inaccurate on their mortgage statements. That's what they agreed that they're not going to fight, that they were doing that. They were charging borrowers unauthorized fees for default-related services.
Unbelievable. Well, we see that all the time,
All the time. Oh, we did a property analysis, so we did $250, and then under deposition, you find out, what is a property analysis? Oh, they had somebody drive by.
Right, there you go.
Drive by.
$250 drive by.
Yeah.
What was he driving by in a Ferrari?
So, that was the kind of thing that they were adding these default-related fees on, even though they weren't really doing anything. They were imposing, and you all have heard these stories, imposing force-placed insurance on consumers when Ocwen knew or should have known that the borrower already had adequate home insurance coverage.
Well, that's an everyday thing.
We see that
all
the time.
I mean, it's terrible. And it's not just force placing the insurance is force placing it at a cost that's 10, 15, 20 times more than it would ordinarily cost.
And force placing it to the point where it ends up with the borrower being stuck in foreclosure
Right,
because
right.
they can't pay. They used to have a $1,200 a
All
month
of a sudden,
mortgage
now
payment.
it's $2,200.
Right.
Right. And
Well,
they can't afford it.
Right. And it's all because of the force placed insurance, and the lender's going, you know, you didn't show us proof of insurance. And the borrower is saying, yes, my insurance agent faxed it to you. I faxed it to you. You confirmed receipt 3 months ago. And now we're back to square one with you not believing I have insurance again,
Right.
over and over and over.
And God forbid that in the process, if they change services, you've provided the insurance information
boy.
to one servicer, they change servicers, and all of a sudden a new servicer comes back to you. Well, you don't have insurance, but I provided it over there. And you've got to go through the whole rigmarole again.
Yep. And that's another issue that Ocwen actually consented to a judgment on, and that is that they when it would transfer, when a property would transfer to Ocwen as a servicer, that they would not
honor any existing sort of modification agreements. We've seen that. A person could be in a trial modification. The loan gets transferred to new servicer, and guess what they say? Well, we don't acknowledge the fact that you're in a trial modification. We don't know. You have to start over again.
Right. Oh, we've seen it with permanent modifications. We've seen it where Ocwen just bought in the past year a lot of servicing rights from Bank of America. I think it was over like $181 million worth of mortgage servicing rights. So Bank of America had a lot of our clients in trial modifications or like one or two payments into a permanent modification. The loan mortgage servicing rights get transferred over to Ocwen, and Ocwen sends my client a mortgage statement reflecting the old unmodified amounts. And of course, my client comes back to me and free of charge because I'm a nice person. I go back to Ocwen and fight them and say, look, I'm sorry, but the terms of that mortgage were already legally modified.
By your predecessor, right?
Yes.
Yeah.
So you can't, oh, no, we don't have any record of that. And I'm like, oh, I don't care if you have a record of it or not. I have a signed agreement. It's a binding contract, folks.
Right.
You don't have the right to go back to the old terms. It was permanently modified. You might not like it, but you have to abide by it. And if you don't, I'll take you to court. And
Right.
so, again, requiring an attorney, if my clients didn't have an attorney that was willing to do that.
Yeah, we got railroaded.
Yeah, a lot of borrowers would just get railroaded and think they have to start the process again, or again, they end up in foreclosure. I don't know why I'm so riled up today. I
You
think
are.
this Ocwen thing today, just seeing again that, these mortgage servicers doing such wrongs against homeowners. Where are the whistleblowers? Where are the people that work for Ocwen, for all of these mortgage servicing companies? Where are the... Thank you, Will. Good point. Where are the indictments? Where is our Attorney General, Pam Bondi, when we're sending her letters showing her that these mortgage servicing companies are doing it? When New York is filing claim after claim against these mortgage servicing companies and getting settlements, hundreds of millions of dollars in settlements for the residents of the state of New York who have been, improperly treated by these mortgage servicing companies. Where is Pam Bondi doing that for the residents of the state of Florida?
When we have been on the top of the list for foreclosures for the last, 5, 6, 7 years.
Yeah.
Why aren't we getting the same service?
Yeah, it's very frustrating. So excuse me. I know I'm kind of on a tirade today, but I'm a little jacked up. I'm a little excited about some things, and I'm a little bit, I read these things, and it really drives me crazy because when are the homeowners in the state of Florida going to be treated fairly? Who's going to put these mortgage servicing companies' feet to the fire? Call the law firm of Morris DuPont. We're here to help you. I'm going to give you the number. It's 800-974-2712, the phone number for the law firm of Morris DuPont. We have people standing by right now who can take your call and schedule your free consultation so that you can speak to us about your issues. That's 800-974-2712.
Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. Attorneys Will Morris, Shay DuPont, here for you. The toll-free number to call the show and talk to the experts is 866-610-NEWS, 866-610-6397, AT&T Wireless customer star 610.
Well, I know you've got a bad head cold, and I know it's hard for you to talk, and you might be coughing, but there's something I want to talk to you about
Go
because it's so funny. You know, folks, foreclosure defense attorneys have what's called a listserv. I don't know if you know what a listserv is. I didn't know what a listserv is before, but I'm on a listserv. And a listserv is where all the foreclosure defense attorneys that want to in the state of Florida sign up, and we do this email together where you can comment and you can post things, you can ask questions of other foreclosure defense attorneys, and all of us can read that email and we pipe in. So there's constantly threads going in this. I get comments from the listserv about twice a day, and I do read these listservs and I forward a lot of information to the foreclosure department. They're on some other listserv. They've forward things to me. So last week after the show, I was reading the listserv, and there was a foreclosure.
2 weeks ago.
Was it 2 weeks ago?
2 weeks
okay.
ago.
So 2 weeks ago, I'm reading the listserv, and there's a foreclosure defense attorney on the listserv that talks about how he had been listening to the radio and heard some foreclosure defense attorneys talking about quiet title. And my comments about quiet title were often that it's a myth, that it can be done, it's very unusual circumstances, courts are courts of equity, and Will and I were talking about that.
We've always had the opinion, at least I have, and you as well, that courts of equity, which is what quiet title courts of the.
Yep, and I knew it would be hard for him to talk about it because he has had a cold. I don't even know why he came in today, folks, because really, he's got the biggest head cold and his throat is killing him. On the breaks, he's sitting there chugging honey. But go ahead, Will.
I want to say this, but my cough is not allowing me to. But anyway, look, the accolades and all, even the commendations to the contrary, I'm not a very smart guy. What I do, I think what a smart guy would do, and I do it. But, we made these comments 2 weeks ago about this quiet title, and we thought it wouldn't work. And on the blogs you were talking about, they came back and said, well, we're not so sure. We're going to have all the gurus talk about it and figure it out. I think we even went so far as to discuss whether or not we should have some sort of seminar where all the foreclosure defense lawyers get together and we try to discuss this issue.
Yeah, I want to post that on the blog and say, okay, let's all meet and let's all talk about with this issue of quiet title. Can it, let's all brainstorm together. You bring your experience to the table. We'll bring our experience to the table. And of course, I want quiet title to work. Believe me.
I want them too.
Yeah. Who wouldn't want it?
It seems like a great idea, but I've always had reservations about it because I think, courts of equity are going to loathe to give somebody a free house simply because one person sat on their rights and can't enforce it. And so I went back and I started taking a look at it and researching it a little further. And lo and behold, I found this case out of the Middle District. Actually, Michelle and I found it, our bankruptcy lawyer, out of the Middle District of Florida Bankruptcy Court, which seems to indicate that the quiet title concept might actually work. The court relied on, albeit the case was not wasn't contested by the bank itself, so whatever the party seeking the quiet title, whatever they said went through as the law. But the court seems to think that if a person a bank doesn't foreclose on the property in 5 years, the right to foreclose obviously is gone under the statute of limitation. But then the court went even further and said that there's a statute in Florida that says all liens expire 5 years after they mature. Well, let's think about it. You've got a mortgage that says you've got 30 years to pay it. Well, I would assume that after the 30 years have passed, 5 years after that, it can no longer be enforced. But what the court went to say is, look, if a bank has...
Oh, poor guy.
Wait a minute. If a bank has accelerated the balance of the mortgage, they have changed the maturity date of the mortgage to the time they accelerated the mortgage. So therefore, 5 years thereafter, the lien ceases to exist under Florida law.
I like it.
What a great concept. And I thought about it. And I tried to come up with all sort of arguments against it. And I thought, I said, wow, that is interesting. Sure.
Look, all we need is a court to agree with us. We can put forth any argument we want, however insane it is. But although that's not an insane argument, we can put forth any argument we want. We just need a court to agree with us.
That's not insane at all.
Yeah.
And as try as I might to find some insanity in it, I couldn't.
I like it.
And, yeah, because think about it. The mortgage says 25 years. The bank has now said, look, because you defaulted on the mortgage, I'm accelerating the full balance, so therefore the maturity date has now changed to right now.
Okay, let me play devil's advocate on
Go ahead.
that, Will. Okay, so you keep using the word mortgage and lien.
Right.
Because the issue is when the statute of limitations after the default, 5 years for the lender to file a foreclosure action and foreclose on the property. We all agree that that statute of limitations is correct. The time of default, notice of acceleration, notice of default. Okay, the different courts might interpret that differently, but we still got this 5-year statute of limitations.
Wherever you start,
wherever you start the clicking from.
Right.
And so the lender can't foreclose, but the argument was that the lien continues to stay on the property.
Mm-hmm.
Okay, let's say that under your argument, the lien is extinguished.
Mm-hmm.
You still owe under the note.
Yeah, but wait a minute. They can't enforce against the note because that's also barred by the statute of limitations.
Huh?
Well, they've got 5. I forgot what it is. A contract, 4 or 6 years to sue under a contract. And if that is also barred by the statute of limitations, they can't do anything.
I'm really liking this. So this
right.
is a reason why I think all the foreclosure defense attorneys that want to, I think we should put it back on the blog and say, let's meet. We have a beautiful theater here at Clear Channel that they would let us use. I'm going to put it on the blog. I'm going to suggest that any foreclosure defense attorney that wants to sit there and talk about this issue of quiet title, let's do it, and let's start presenting some good arguments and some continuity amongst us so that we can start to try and get this in front of as many judges as possible and find some judges that are going to agree with our position, because those are the judges we're going to want to use that argument in front of.
Right. Because, I think a lot of judges are going to be resistant to the concept of giving a person the property free and clear. But I think if presented with proper arguments, as this one seems to be, I think they would have no choice.
Sounds good. I like it.
We have a phone call. Hi, Simon.
Hi, Simon.
Hi.
Hi. What can we do for you today?
I have a question.
Okay.
I have many properties. One of my properties that I have is a piece of land that I have a mortgage on it. It's a $500,000 mortgage that I've been paying for the past, 6-7 years. The land is underwater substantially. My question is, in my situation, can I do modification for it? I won't qualify for it because of my income and all this kind of stuff. I know I won't qualify for it. Is there a program that I can modify the mortgage?
Yes, absolutely. You can modify vacant land. But you know what? It rarely happens, and I'll tell you why it rarely happens that people modify vacant land. And that is because vacant land is normally so underwater that unless you get a massive principal reduction, even with a modification, it doesn't make sense to continue to pay on it because it's not generating any revenue and you're not living there. So it rarely makes sense. We've got, I don't know how many clients in the Cape Coral area that bought vacant land over there. I mean, there's so many people on the East Coast of Florida that bought land over in Cape Coral, and that land is worth next to nothing now. You can't give it away. So what they all did, they wanted loan modifications. We ended up short selling all of that property. That they just wanted to walk away because it was just bleeding money. So, you're welcome to come in. I'll do the analysis for you, tell you whether or not I think it should be modified or whether or not I think a short sale makes sense. Honestly, I don't care either way, but I'll show you how to analyze it correctly, because you have to do an analysis, and and there's a way of looking at it to decide whether or not this is a property worth keeping. It depends on how underwater you are. It depends on whether or not you can get a principal reduction. It depends on how soon you plan on doing something with the property. If you're going to build on it and make it into a rental income within the next 3 years, yeah, maybe it'll make sense, but very often it doesn't.
Mm-hmm.
Well, it's 30% underwater right now, and I don't want to affect my credit. My credit is unbelievable. So for me, it's not worth the money to give up the property and ruin my credit for that.
Okay, so I'm not talking about
money is not worth for me.
I'm not talking about ruining your credit. The reason why you have a credit score is so that you can borrow money at a lower interest rate. So what are you planning on doing for the next 3 years? That's going to be the question I'm going to want an answer to after the break.
And you're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. 800-974-2712. 1-800-974-2712. We've got Simon's call to get to right after the break here on the Home Mortgage Law Show. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. 866-610-NEWS, 866-610-6397. Toll-free number here in the home stretch to squeeze in your call, your question, your concern, your story. 866-610-6397. AT&T Wireless Customer Star 610. Attorneys Will Morris and Shay DuPont. And Felicia, welcome to the show.
Hi, Felicia.
Alicia?
Hi.
Hi.
Good afternoon.
Good afternoon. What can we do for you today?
Okay, I heard you were talking about the 5-year if the bank did not foreclose or put a sale date on the property. I'm wondering if that can help me. And prior to this, Bank of America had lost my original note on the file. Since late 2008, I did not pay mortgage, and they really did not put a sale date yet on the property.
Okay, so my first question is, has Bank of America actually served you with a foreclosure action?
Yes, that served me. That's correct. They did serve me, and I took it to an attorney.
Mm-hmm.
And has that foreclosure action been dismissed, or as you said, it's ongoing, but they just haven't set a sale date yet?
It's still ongoing. They haven't set a sale date yet. I think they're in a conference meeting.
Okay.
Mm-hmm.
And what is your intention with the property? Do you want to stay in the house, or would you just rather short sell it or let it go?
I want to keep it.
You want to keep it
at home, and yes, and I'm a Fannie Mae. It's a Fannie Mae loan. Can I get a principal reduction and forgive the other monies that I owe?
Because it's a Fannie Mae loan, you cannot get a principal reduction. What Fannie Mae can do is they can defer some of the principal and put it off to the side and have it be non-interest bearing. So let's find out how much you owe. How much do you owe on the mortgage today?
164.
And what's the current market value of the property?
The current market value is about 115. It needs a roof. It's about 115.
Okay, so there is about $50,000 in negative equity on the property. So, what?
Okay, I have a second mortgage of 50.
Okay, well, hopefully that second mortgage of 15 is now charged off or has been forgiven, because the second mortgage was completely unsecured. So we would want to make sure that we got that second mortgage forgiven completely or settled of some way, because there's no equity in the property for the second mortgage. So let's focus on the first mortgage, which is a Fannie Mae note. We know you can't get a principal reduction, but Fannie Mae can defer up to $50,000 of that mortgage, put that off on the side so that the interest-bearing amount that you would be paying for your mortgage payment would be the $115,000. So it would be $115,000 at 4.5%. So that is what you could see. You know, I can in a consultation, I can actually sit there and try and give you an estimate of what I think your best possible outcome could be. What I would do is I would simply go to a mortgage calculator and I would put in $115,000, and then I would put in the interest rate. What I normally do is 2%, but that's for a HAMP loan mod. I would put in 4%. And then I would look at what the payment would be over 40 years, and that's $480 plus your escrow. Let's estimate that at $200. So the best possible option that Fannie Mae could do for you is somewhere about $680 for a mortgage payment. Now, granted, you'd still have negative equity on the property, but this is one of the things I do in the consultations. I ask people, look, if you can get your mortgage payment down to $680, even if you still have $50,000 in negative equity, do you want to stay in the property? Well, if you could rent somewhere else for $300 a month, the answer would be heck no. But if to order to live somewhere else, it would cost you $1,000 a month, well, who cares if you have negative equity? It's better to stay put where you are.
You got to pay to live somewhere.
Right, Will. You got to pay to live somewhere. So these are the kinds of things that I do in the consultation. I walk you through all of these things. But as far as the foreclosure goes, the clock on the statute of limitations stops. The statute of limitations is told at the time the lender files the foreclosure action against you. not at the time that the lender completes the foreclosure sale on the property. It's really tricky. I know this is some legal nomenclature, but it's the filing of the foreclosure action. So if they did that within the 5 years from the date that you stopped paying in 2008, they're okay.
Oh, okay. So when I need to set an appointment to come and see if they can do the modification.
I can see whether or not it makes sense for you to do a modification. Absolutely. Who's your lender?
Yes,
who's
my name is Bank of America.
Bank of America, who's doing great loan modifications these days. Yeah, what part of town do you live in?
I live in Hollywood here, and I really want to keep the home because if I go to move it may cost me more money in rentals.
Exactly. That's a good analysis. Okay, well, come see us in the Aventura, probably, or the Fort Lauderdale office is best. So call the office. It's 800.
Yeah, I got the number.
Great. 800-974-2712. And you can meet with someone in the Fort Lauderdale or the Aventura office if you live in Hollywood. Probably the most convenient for you. Thanks for listening to the show, Felicia.
Sam, welcome to the show.
Hi, Sam.
Yeah, hi. My question is a little bit different than the stuff I usually hear you talk about. I closed on a house in November, and at the time I was assured by the lender that I did not need windstorm insurance, and the windstorm wasn't included on the HUD-1 policy. And then about 3 weeks after closing, I received a letter saying that they were going to force place insurance if I didn't get it. I was wondering if you think I have any standing or if this is just the way things go.
No, I don't think this is the way things go. I think you have standing against your realtor, who should have been able to inform you whether or not windstorm insurance was required for that property. I think you have claims possibly against the title company, and I think that you have, you can also check. I don't know how you check, but there's got to be a way to check as to whether or not you really do need windstorm insurance. The realtor and the title company might have been right. You don't need windstorm insurance. We see that all the time with flood insurance, where these mortgage servicing companies force place flood insurance and you don't need it.
Particularly
and
on condos.
We've disputed it tons of times. So the first question, the first question is, do you really need windstorm insurance?
Well, I mean, that's up to interpretation. The house is a concrete home with a concrete roof, and it has, hurricane windows and doors and whatnot. But, to me, the crux of the matter is that they verbally, and this isn't the real estate, this is the actual lender.
And that's why all real estate contracts must be in writing, because anything said verbally does not count. You cannot even use verbal statements, parole evidence in a claim against real estate. So whatever they told you doesn't count.
I have it in email.
I like it. I like it. Now you're talking.
I have several emails where they told me that it wasn't necessary. And then, like I said, all of a sudden, 3 weeks later, I received this letter. And, I wanted to do something, but I thought that my best course of action was first to get the insurance, just to get them off my back. And then now I'm at a position where I would like to do something.
Now you can fight it. Okay, what I would do is
smart strategy.
I would first be going to the Florida Insurance Commission to see and find out under what statute you can figure out whether or not you are required to have windstorm insurance on that property. Then if you need it, obviously you got it, so you're safe. But then going against the lender and making a claim because they told you that you didn't, and that you based your entire calculations on whether or not you were going to buy that property, and it was affordable for you because it didn't have windstorm insurance. And the reason they probably lied to you was so that they could get you into a mortgage where it would be 31% or less of your gross monthly income to make it affordable, so that it could be approved and they could sell it to Fannie or Freddie and blah, blah, blah. And then they turn around and stab you in the back. Totally normal lender behavior.
But you do think I have something that's actionable here? It's worth
only if you really are required to have windstorm insurance. That's the first hurdle you have to overcome.
I see.
Just because a lender says it's so don't mean it's true.
Okay, but the fact that they didn't include it on my HUD-1 statement, does that have any bearing on anything, or that's just
It
incidental?
depends on whether or not you really needed
Right.
it.
Listen, just because you got...
We gotta go.
We got to go? Oh, what? There
Give
you
us
go.
a call.
1-800-974-2712. 1-800-974-2712. We'll see you next Saturday here on the Home Mortgage Law Show.